Assalamu alaikum, everyone, and thank you for attending and also greeting our audience online. Today we have this talk about intellectual property with Yayoi. We're so lucky. I see very familiar faces. I'm so happy. So one of the things that seems to be very confusing to artists as well as art organizations, at least here in Saudi Arabia, because this is a kind of a new territory for us, is intellectual property. And what makes it even complicated is that the nature of art is very changing, the role of the art. What we can recognize as art today is different than what we used to recognize as art in the past. So, which makes it even more difficult to find a very comprehensive kind of a legal system that covers all issues. So today we are lucky to have Yayoi with us. She's a lawyer specialized in intellectual property, and she has also a very great experience representing artists who does different kind of work. And we because of the broadness of the topic, we have decided to focus on a few pressing issues that are related to what artists and organizations are facing today, and especially in relations also to the work that we see in the Biennale. We see so many commissioned work, installations, and performance art, and so on. So, but before we start, I was explaining to Yayoi that in other fields, we keep having this fight over what is intellectual property, what does it cover. So if you can explain for us the difference between copyright and intellectual property as an introduction to the question that will be followed.
Yes, and thank you so much, Eiman, for such a generous introduction. And also thank you so much to the Diriyah Biennial for having me, and in particular, Raneem Farsi and her team who has brought me here. It is such a great honor to be here in the region and to be able to look and learn and speak with you all. And so I do want to point out that I do practice law in the United States. And so much of our discussion today will be US law focused. That having been said, I really hope to be able to share with everybody some best practices and standards and even mistakes that I've made in the past and I've experienced in the art world, with the hope that some of these standards and best practices have a bit more general applicability. Even before we dive into Eiman's question, which is actually not so simple at all, I wanted to tell you a little bit about what I do. I'm honored to be an art lawyer, but at the same time, many people ask me, what do you do as an art lawyer? What kind of law do you actually practice? And so the field of art law is still developing. It's still quite new. But in the United States, it's actually an amalgamation of various bodies of law as it's specifically applied to the art world. As you all know, the art world is a very specific and unique and amazing place. And so various bodies of law are then applied to specific, unique, and wonderful, and sometimes challenging situations. So it's everything from commercial contracts, property, tax law, import-export, and commercial contracts. It's all these sorts of things as they are applied to the art world. Let's dive right into Eiman's question of the definitions of intellectual property and copyright. So this is a personal definition and trying to make it a little bit more simple and general. Intellectual property is rights afforded to fixed formalizations of knowledge, and there are different applicable bodies of law, including things like copyright, trademark, and design rights. And so intellectual property sits at the top, and then copyright actually sits underneath that as a particular format or a particular topic. And so in the United States, copyright is a specific form of intellectual property right, and it's for fixed, tangible forms of original expression. It's meant to help authors and artists exert their property rights to their original works of creation, and also to gain some form of financial benefit. In the United States, copyright is a bundle of rights. What does that mean? It means that the artist who creates an original work has a series of rights that they can then decide to share on their own. They can divvy it up and share it amongst different people. And it's, for example, the following kinds of rights. For example, the right to reproduce and copy the work. It's also the right to distribute those copies made. It's the right to display it and exhibit it, kind of like how many of the artists here are getting to do so at the Biennale. And it's also the right to make derivative works as well. And that means the right to adapt original works and then disseminate it.
Okay, thank you. So, and here lies the tricky part, which is most of contemporary artwork are ephemeral, which means they are temporary. And if they are temporary, then also they mostly don't have a physical presence, which always become the issue with artists when they are commissioned to do a work for an exhibition or even for a private collection or a museum. So we will try to make our question as simple as possible, but these are always on the mind of the artist whenever they are asked to do a commission to do a work. So one of the things, if someone is doing an ephemeral kind of work, what are the limits of the artist's intellectual property for that work? Perhaps they could at least know the basics that they could write in their contracts, and they are, because as we discussed before, artists feel kind of ashamed to negotiate their rights, so at least they would have a benchmark or an idea of what to ask for in their contracts.
So Eiman, you're already thinking like a lawyer, and thank you for answering your own question, because I think one of the key takeaway points that I think both of us have is that artists should feel that they have the absolute right to ask for letter agreements and also the right to understand what's in them. And artists should not feel ashamed to say that part, bless you, I'm not sure what this means. Please tell me what this means. Or also, artists should also feel the right to be able to negotiate their terms, to advocate for themselves. And I think that a discussion of temporary works is so important and so timely because we find ourselves in the Biennale where so many artists are asked to create temporary works or commissioned, requested to make new commissions. So when I think of temporary artworks, the examples that immediately come to mind are temporary site-specific installations like Muhammad Shono's on Losing Meaning, which is in the Biennale. Are you okay? Bless you. Bless you. God bless you. And dance performances, like the performance that is memorialized in Marwa Al-Mugheth's The Sea is Mine. Now, it's also important to note that the law is unfortunately always outdated in this regard. And maybe that's because, as Eiman mentioned, a clear definition of art is even very difficult right now because so many artists work in such a variety of formats. And this is actually also why we love our artists, because our artists push the boundaries of creative expression. So in the United States, if we go with the basics, copyright protection comes about in fixed works, and concepts can't be copyrighted. So if something is very, very temporary, it unfortunately doesn't necessarily receive copyright protection in a clear-cut way right off the top. However, there are most certainly ways in which copyright can still support these artists who are working in site-specific and temporary ways. So for installations, for example, I suggest that artists take documentation of the work, whether it's photographs or videos. For things like dance performances, again, a video performance, a video documentation of the performance can be copyrightable, as would be even the notations of the choreography, like a dance script.
Yeah. So one of the things that from my work, and I'm sure Ranim also experienced from working with artists who have an entire team or collaborate, is that even the artists themselves feel kind of concerned. Should they credit their team in the credit line, or if they are paid, then that's it, or should they basically make it like a written agreement? Because there's always someone upset after a group or a collaboration if they are not mentioned in the credit. And then again, because of the pride of the artist, they feel that they have created the main vision, the creative idea, and so on, and then these were paid. They are unentitled to be credited. So at least I know that everything is negotiable, but in terms of standards, is it their right to be credited in their credit?
Yeah, and thanks for that. And I think in some ways the standards are still developing, right? In particular, as Eiman mentioned, there are so many artworks now that require a lot of people to work on them, that it really becomes in some way a collective and collaborative effort. And why is that the case? It might be really because so many of the skills needed for an artwork are quite specialized. For example, in moving image art or digital art, where there might be a creative leader, but then there's also a whole group of other people involved in finalizing the artwork. For example, like the actors and soundtrack composer, for example, in Koki Tanaka's Abstracted Family, which is also in the Biennale. So I think the analysis of what should happen, it happens always on several levels. And I think, Eiman, you were already alluding to some of those things. And so on the legal and financial side of things, what are the contractual rights that have been negotiated among the parties, if at all? Right? Are there, for example, letter agreements being issued from one party to the others? Is there anything about rights in those letter agreements? And there's no right or wrong answer, but I think it's always important to start talking about those things and then trying to memorialize them as the project continues. It's almost too late to do that if the project is already done. And then in that case, as you pointed out, Eiman, a lot of people get upset, and we don't want our collaborators to be upset with each other. So if it's in the US, if, for example, a composer creates a soundtrack and then, for example, agrees that what they are doing is what's called a work for hire, meaning that they create something, but they are also giving their rights away, often for a fee, then at least the composer knows they're going to get paid for it, and therefore they're contributing something, but they're also getting a fee for it. Another way to cut this situation is more relational, right? So when after you figure out the legal and financial side of things, very separately, there's still matters of the heart in terms of who feels a sense of connectivity to the project and who wants to be acknowledged for the work that they do. And again, I would recommend that it's important to start talking about those things early on. For example, how should collaborators be acknowledged? And is the collaborator okay with just being acknowledged as a participant? Or would they prefer to actually receive legal rights, which should, again, be in a contract?
Yeah. So in the end of the day, these things should be on the table before even starting the work. And what happened usually is artists would shy away, whether intentionally or unintentionally, from asking these questions, thinking that they could get away with things, but it actually can make the situation even worse afterwards. So it's always better to be clear, right, with your collaborators or even people who are working for you, right?
I think that's totally right. And Eiman, in my experience, I also do find that sometimes artists don't want to discuss these issues.
Yeah.
And not just that, sometimes these artistic pieces are so creative or so innovative that people don't know what they're going to end up with. And so there's this long artistic process and lots of people being involved. And so in some ways, I don't want the contract ever to lead the discussion. If I was advising an artist, I wouldn't necessarily say, well, the first thing you have to do is make sure you tell all of your collaborators that they are just collaborators. I wouldn't necessarily lead with that. But again, a continued discussion amongst all parties, I think, is really important.
Yeah, because this always reminds me of Eve Klein's Jumping to the Void, because the actual work was made by the photographers, yet Eve have claimed all the credit for himself. So now, if we think about photographers, but in another situation, which is if the work is ephemeral, like a performance or an installation that will be temporarily showed and then removed, and a photographer, whether a journalist or an independent photographer, took pictures of that work, what are the limits of their intellectual property over that photographs?
Yeah, and this is such a great question, right? Because our photographers are artists too. And so in general, in the United States, unless the photographers are hired to create work for hire, which we just discussed, right? Again, meaning that if somebody creates something for work for hire, they're giving away their rights, often in exchange for a fee. So unless the photographer specifically agrees that they're creating something work for hire, the photographer will have copyright protection in the works that they create. Why? Because these works are original, fixed, tangible forms of expression.
So after the exhibition, the artist cannot prevent these photographers from publishing their photographs unless they buy it, right?
Yes.
And I understand even buying a picture should also be very clear if you are buying a copy or the entire, like in the past for the negatives and so on, right?
Yes.
So yeah.
So absolutely. So again, Eiman, you're taking all of my words away from me because we are talking about contracts. And of course, it's important, again, if you're a photographer and you have been hired to potentially, for example, photograph a installation of a museum, for example, it's important to figure out what rights you are giving away. You might be giving up all of your rights, or you actually may be able to negotiate that you're giving away the rights exclusively for a set period of time only to the museum, for example, and then it comes back to you. And so I think there's sort of a variety of ways to cut that.
Yeah, just to give context to this question, why I'm asking, maybe Ranimi will be interested. Safiya bin Zagar, a famous artist, she hired a photographer in the 70s to photograph all her paintings, and these are physical work, for a book. Then afterwards, she learned that the photographer is actually selling copies, posters of these photographs in Geneva, and then they had to go to court, and then he claimed that they paid him for the photographs, but they never bought the negatives. So, which is why I'm asking this question.
Yeah.
Yeah, and she had to buy it. eventually.
And you know, this is again sort of while I'm a lawyer, I don't recommend people going to litigation, especially in the art world, right? I think it takes a lot of money, a lot of time.
And you always lose.
And always stress also, right? And it's kind of sad to think about the fact that you're bringing somebody to court when they were maybe a collaborator, or maybe you relied on them to help you with your work. And so my goal really is to try to help artists avoid that kind of horrible situation that you just gave the example to.
Yeah, I think it's always, I actually have heard that so many times that it's better to have someone that could secure your contract better than just basically going to court afterwards, which also takes us to a situation that we face on a daily basis nowadays in such events, which is when the collaborators are actually the audience, when a work of art is never alive unless the audience participate in that work, then what happened is that also artists find themselves kind of confused whether they should use the pictures of the audience or not. Is it a risk to have them being photographed without a written consent prior to that?
So that's a very contemporary question, right? Because in some ways, I feel like we are always in the background of somebody's iPhone photo or video. That's just kind of the world that we live in.
Yeah, but Yayoi, by the way, this is a very sensitive issue also to Saudi Arabia, because there are politics to taking someone's photograph. So then add to the situation if it's also related to intellectual property. So we need your advice on that.
Yes, thanks for that. And so in the United States, people also have the right to their image too, right? All of us, in some ways, have the right to the way that we are documented and evidenced in the public eye. But of course, here we find ourselves where everybody has iPhones. And then Eiman, your very pertinent question about what happens when an audience member or an audience is needed to complete the work or to engage with the work. And so technically, the artist should receive written consent from the audience members. But I don't always advocate that that's practical or even possible. So I think the practical approach would be, for example, having a sign-in sheet. And that, of course, also depends on the scope of the audience participation as well. Like if the audience member is expected to stay there for a set amount of time, and their image or their visage appears in documentation or footage that the artist takes, and that the artist needs that archival documentation, then my recommendation is to have a simple sign-in sheet that says, hey, I understand that I'm asked to participate and that my visage might be part of the archival footage of the artist. But again, even if that is impractical or not possible, then just even transparency is important too. Like so signage at the entrance of the artwork that says, hey, I'm the artist, I'm going to be taking photographs or videos of you all kindly participating in my project. Just letting people know. Transparency, I think, is really key.
Can I ask this question? You have something written on your on the ticket of Diriyah Biennale, but I don't think it appears until you already booked the ticket. It shows that you have to consent to be for your image to be like taken or photographed and whatever. And it seems kind of, it's good, it's clever, but I know so many people will kind of taken back by it because they imagined the worst, to be honest with you. So again, this is really important for an organization to do, but then here in Saudi Arabia, we are lucky that people are not very skeptical about these issues, but could be in other place an issue. If for example, they didn't notice the sign or so can they object afterwards?
Yes,
against
and I think audience members can always object, but then I think the interesting question is, what does the artist do with that? You know, is it possible for the artist to edit out that documentation so that person is not in there, or blur it, as you say, or what have you? And I think for the Diriyah ticket example, maybe there should just be something that's sort of on the web page that says, you know, thank you for kindly visiting, and because we're so excited to take footage of our inaugural biennial, there will be lots of cameras and lots of things happening, and we hope you enjoy your visit. Even that might be better than nothing.
Yeah, it's true. So then also, like we talked about the audience, right? And then also the team. If you like would allow me to jump into the limits of the organizations, right? Because so many of the work we see today in Saudi Arabia is commissioned. And also we have so many generous collectors and art lovers who would give endowment to artists to do certain work. So what are the limits of their property right? I told you about the situation also where organizations would even buy a work of art from a pioneer artist, then assume that they already also own the full intellectual property, so they would copy the images over all their reproductions and stuff and sell it without giving percentage of the sales to the artist or their family. So is this legal? Is it right? What are the limits of both?
Yes, thanks for that. And I think maybe this might be like another key takeaway from our conversation today, at least in the United States regarding copyright. Copyright remains with the artist or the creator, unless that artist or creator decides to give that right away. It is your right to give away. So unless the institution or sponsor has specifically negotiated rights to that work, and generally they don't. I mean, sometimes people ask for it, but I would recommend as an artist, you try to push back to that. The underlying copyright always remains with the artist. And in some ways, this is an element of control. Right? So as arts workers like Eiman and I, we support our artists. And artists, we support and love them because they create original forms of expression. And that's in some ways why I'm in the art world, and I'm honored to be in it. And we want artists to feel empowered to say, copyright is something that is a tool for me to be able to use. I am retaining copyright in the work that I create, and it is within my control to figure out how to share that right.
Yeah, and one of the things that we have discussed, and casually probably, but it is a very important issue, is that maybe the audience don't know that some of the audience intellectual property for art in Saudi Arabia falls under the what we call نظام حماية حقوق المؤلف, author's right law. And we have in that law an article about also tracking an artwork, نظام التتبع. However, like we were discussing, it should be a practical system that helps artists to get royalty fees in case they, for example, sell at least a fraction of the percentage of the copyright and so on. But the problem is that we have the law, but we don't have the system, the infrastructure to implement tracking and also, but it's not possible. I was telling Yayoi about nowadays with Tawakkalna, everything is on Tawakkalna, even the if you own a property, it is registered. So why not also have a tracking system for art or even luxury goods and so on? So one of the questions also related to that aspect is that if an organization would pay you to do an artwork, they must have fundamental rights, and also the artist would have fundamental rights. What are these fundamental rights that they should, at least there should be basics and already known in the first draft of the contract? Can you explain, please?
Yeah, thanks for that. And so I think Eiman is specifically talking to certain examples where an institution or a commissioning organization has commissioned an artist either for temporary display or potentially for an acquisition for permanent display. And we keep coming back to, this is our second takeaway, or maybe our third one, that the most important thing is for all parties to discuss ahead of time, have a robust discussion, and attempt to come to some sort of mutual agreement about that project. And again, there's no right or wrong way to do this. It's just more about that conversation process, which is then memorialized in a contract. So from the artist's side, what sorts of things should the artist be thinking about? And of course, the artist is probably super excited, super honored, but that doesn't mean that the artist does not have leverage to make these discussions and make these agreements with the institution or commissioning organizer. So I like to think about it in terms of a timeline. So during ideation and production, questions like, does the artist get some sort of production fees at the top? Is it an advance? Or is it a non-refundable artist fee? Right? What about the budget, right? I know that many artists don't like talking about money because they don't want to participate within the commercialized area of the art world. Fully understand, but at the same time, I think it's really important to have those honest conversations. There's nothing shameful about talking about money, especially if it's something that is owed to the artist. Right? Other things, will the artist have an opportunity to do a site visit? Right? Will they be given time to do that? Are there more fees involved? So that's part one, during ideation and production. Two, once the work is created, right? What is the organizer agreeing to do to bring the work over and to exhibit the work? Are they going to be paying for crating? Are they paying for shipping? Will they insure the work, right? Will the organizer be able to ensure that the work will be safe while it's on display? Will the organizer take pictures, documentation of the work that'll then be shared with the artist?
When they take the pictures, is it negotiable, like to have shared ownership over this documentation? Because I assume that whoever pays for the photographers will own these documentation unless negotiated in the contract, right?
Yes, that is correct. And we come back to the sort of the distinction between property rights and copyright, because usually the commissioning organizer, as you said, Eiman, will commission some sort of photographer to take this documentation. So the property rights of these photographs will likely go to the commissioning organizer. But that does not mean, of course, that the artist has given away the underlying copyright to the artwork that's actually in the imagery. So I think at least artists should request that there is a copyright credit that says copyright artist, artwork, copyright credit, and maybe even they say, please give me a set of these digital images. We agree with the commissioning organizer how the credit line will be, and that the artist can use these documents as documentation of the fact that they've participated.
And also there's always a very important period that everyone forget about, whether the commissioner or the artist, which is what happens to the work after the event. And like maybe the audience, some of the audience, especially if they are young, wouldn't understand, and they would assume the artist will be happy to have the work. But in most cases, these works are huge, so they will cost a lot of money to be de-installed and then created and also shipped and then stored in somewhere. So it will be eventually a problem. So I guess it is a responsibility for both parties, right, to discuss and negotiate.
Yes.
Yeah.
Again, we keep coming back to discuss beforehand, have an open conversation. I mean, even if the artist doesn't know or they're not sure, I think it's even worthwhile to say to the organizer, I'm not really sure what I'd like to have happen to this work after the exhibition is over, but what are your plans? It's just an opportunity to start these discussions, because I think sort of the saddest thing would be if the work is dismantled without the artist even recognizing that the work has been dismantled.
Yeah, also, there's also a situation I have witnessed also where the commissioner will allow the artist to take the work, right? And then the artist will be confused because it is commissioned. So are they allowed to sell it without the permission of the commissioner? Should they credit the commissioner or not? Should they take permission before showing it? Can they produce copies of it? Can they produce editions, which is something I know that we both are not happy about, but it happens where artists produce editions, and unfortunately most of the time actually it is lower in terms of quality, not quality, but the spectacular aspect of it is lost. So what is your legal opinion about that?
Yeah, and I think you just threw so many interesting questions about that particular situation. And again, we keep coming back to openness and mutual discussion ahead of time is the most.
We need a lawyer,
important thing.
That's the bottom line.
And maybe artists and commissioning organizers need support and advocators who can advocate on behalf of each other in these discussions, right? But I also want to point out that sometimes in the United States, it's not possible for artists to hire lawyers, right? So we have to help them, in some ways, help them fish on their own. So give them the legal tools or the strategy tools or the negotiating tools to advocate for themselves.
So answering the questions.
Yeah, sorry, I have to answer some of these questions. Let me please answer.
Do they take permission or not? Bottom line.
But the bottom line is that if the artist has retained their copyright to their artwork, then they have the right, they have the intellectual property rights to that artwork. Yeah. Now, separately, you know, the question then becomes, does the commissioning organizer, have they actually said to the artist, no, actually this work is ours because we paid for it? Yeah. And then in a very small minority of cases, sometimes I see in these commissioning contracts that if the artist decides to sell their work after the exhibition or the fair or the project is over, then sometimes the commissioning organizer says, then please reimburse me, artist, for the amount of production costs or a certain portion of the budget that we have given. Now, in all practicality, I'm not always sure if the commissioning organizer actually follows through to exercise that right, but I do sometimes see that for particular commissioning contracts that have very, very large budgets.
So jumping so far ahead, like, sorry, we have prepared so many questions because personally I am interested, but because of the time limitations, I really want to discuss a very, I would say a very new territory here in Saudi Arabia, which is inherited art. And also whether you are inherited this work from a collector, your relative is a collector or an artist, because in most cases, and I personally, this is a personal interest, I always like try to help artist families to deal with the legacy, because we will not go through the many problems that I see today, but one of the things that they have is that loaning the work to an organization. And I'm sure many people hearing us today, they have heard that question. Should we ask for fees to loan our fathers or work or not, or our mother? And then also educating in a way also the organizations on how to approach these the owners of the work, because unfortunately there's so many cases I have witnessed where both are really good people, but each and every party feels that the other party is being rude and asking for so much, or and things that they. So today, what I'm hoping to. I understand my lesson now. It's all about the contract, but at least we could share a common practice, what to expect from both parties. If you are an organization that is taking a loan from someone, or if you are lending your work to someone.
Yes, so thanks so much for that. Because in my day job, I do have one specific day job. I have the honor of supporting the Chris Burden Estate and the studio of Nancy Rubens. Burden was an American artist, so he passed away, so I get to work with an estate. He is known for his varied practice, and he's thankfully collected in museums around the world. Rubens is a contemporary living artist who makes large monumental sculptures. And so Rubens, she has an interest in exploring materials and having the viewers of her sculpture explore the formal relationship between themselves and her work. So why do I say that? Because I will get to your question. Why do I say that? It's because I get to work with an artist's estate. And in the United States also, I would say from my experience, the world of artist estates is still developing. It's an area, I think, of the art world that there are a growing number of stakeholders, but there is still no right or wrong way to run with artist estates. And why? It's because each and every artist estate is unique based on the wonderful work that the artist created during their lifetime. And so the strategy to support an artist estate also needs to be very unique. But things to think about include what was the artist's art historical legacy or art critical legacy or even commercial success when the artist was still with us? Did the artist leave a lot of work in the estate when they passed? Is it organized? Is it categorized? Are people still learning about what the artist left behind? And I also think it's very interesting because artist estates are run by different types of people. It might be run by arts workers like me. It might be run by an art historian, like Eiman, for example, or it might even be run by a family member, and many of those family members are not always in the art world.
The case in Saudi Arabia, and this is why it's very sensitive, because you are talking with someone in a business mentality, but it's still their father or their mother. So, yeah, very endear to them.
Yes.
And also they feel embarrassed should they ask for loan fees or not, which is mostly the case that we face.
So to directly answer that question, with respect to the Burden estate, when Burden gets requested to lend works from the estate, whether it's for a temporary project or a longer-term project or to a museum's group exhibition, for example, I always feel comfortable negotiating a loan fee, but I don't always do that. And why is that the case? Because for me, we have decided in terms of our strategy that it's more important for Burden's legacy to be shared with the world and for Burden's legacy to remain relevant and in conversation with the next generation of artists. And so when I get asked to lend a work from an institution, I'm usually very happy to oblige. Now, that doesn't mean I don't ask for other things. Of course, I ask for proper shipping from an art shipping company. I ask to make sure that the institution has fine art insurance to cover, goodness forbid, if something happens to the work. I request high-res documentation of the works because sometimes we don't have that yet. And of course, we do like scholarly publications as well. So if the curator, for example, is writing an essay or creating an exhibition catalog, we most certainly request that we be included and that we receive copies as well, right? Because all of those things have a cost to the institution. Now, that having been said, I think it's always very possible to ask for that fee. I don't think people should be ashamed to ask for it. And maybe one of the ways to think about it is that there is an admin cost. There's time and resources that are expended from the family member or the estate to prepare for that loan.
It's true, because most of the time, whoever is running the legacy or the estate is actually, he has other, or she has other obligations and other day jobs. They are taking much of their time. So then, I know we might have mentioned that, but I really want to ask it directly, which is who owns the right to the image of that deceased artists, I would say, the artwork, because most times the most incredible, like most valuable artwork we have usually in the estate of a collector, not the original artist. And we see this kind of confusion whether they could do reproductions based off that work of art, or they should go and negotiate it with the family. Because this work was either, and you will be surprised that most of these works are actually gifted to the collector, not sold, which is why it is a kind of a gray area we keep facing. So what's your opinion?
And so we come back to, I guess, with the other key takeaway is that the artist retains the copyright, unless they have a written agreement that gives it away to the collector. And now I think, that is a situation that can get complicated because it's relationship-based too. But I think collectors also need to be educated. In the United States also, they need to be educated that the artist retains the copyright to the image of the work. And if the collector wants to use an image of the work, just because they own the artwork doesn't mean that they have the right to use that image. And a lot of times now, in very short letter agreements between a seller of an artwork, whether it's a gallery or the artists themselves selling to a collector, usually there are terms and conditions related to the purchase and sale of the work, as well as a non-exclusive license. So often the collector will say, hey, I would like to be able to use an image of the work to show that this beautiful artwork is in my collection. And so may I use it for informational purposes, even though the artist retains the copyright. But if it turns out that I end up making tote bags or something like that for my collection and it's commercial, then I agree to come back to the artist for additional written approval.
This is the 1 million real question because it's really like a pressing issue nowadays. So I think we need to stop ourselves from the questions that we prepared and open the floor to questions from the audience. But before I open the floor for question, I need to promote for your workshop tomorrow. If you can just tell us a few like a few things about it, so
Yes.
people would be
Yes,
attending.
I appreciate it. In some ways, I am making the best of my amazing stay here, and so I'm offering myself up to many opportunities to speak with you all. And so tomorrow, I will be giving a short talk about artist-brand collaborations. What does it mean for an artist to work with a brand? What does it mean for brands to license images from artists? And what sorts of ways can artists work in this kind of a way? So that's tomorrow at, I believe, 6 o'clock, I believe, if I'm not mistaken. And then the next day, or maybe the day after, I think on Friday, I will be having a sort of an office hours session, sort of a coffee, an open coffee. So to the extent we can't address your questions today, or if I don't get to talk to you today, please do come back.
Thank you. So any question from the audience? Yeah, Ranim.
Just on the last, first of all, thank you very much, both of you. This combination here is...
Thank you for arranging this talk.
And it's very, very, very insightful. And thank you for your time. Just on that last question you mentioned, what if the situation is that, because Dr. Eiman mentioned something that a lot of these works are already in collectors' estates. And what if, as a collector, you've collected this work from another collection and the artist is deceased? And this is a very old work that, for instance, let's say you buy it from another collector and that artist, as I mentioned, is already deceased. Then you, as the second collector, want to kind of catalog this, you know, for your own purposes. But then there comes a show where an institution borrows the work from you as a collector. So then you're supposed to...
Seems like a real situation.
So then you give them the image of the work, yeah? And then you have a third... شكراً أروى تركت علي على الملأ. But anyways, so then what happens then? The artist is no longer there. Do you go to their estate? What if there is no estate?
So, Ranim, thank you for that very detailed question. It seems
a lot here,
I mean, it's just imaginary. I'm sure that you're dealing with this particular situation, and I'm going to give, in some ways, a very lawyerly answer because we didn't even get to talk about this with Eiman today. But there is what is called public domain. What does that mean? It means that at a certain point, the artist's copyright expires, right? And I think that is partially, and that is at least in the United States, and I believe also in Saudi Arabian
Yes.
law too.
But I doubt that the artists we have like they already lost their royalty, because it's relatively like the oldest work we have is just 50 years. At least, yeah. So it's still under protection,
yes.
yeah.
Yes. Hypothetically speaking.
Very hypothetically speaking, if there is still copyright protection, so if the copyright has not expired, right, then I think the most important thing is if a collector is attempting to use that image in an exhibition catalog, or if a curator wants to use an image of that artwork in an exhibition catalog, then I think it's important to try to find the artist's estate or the agent that is representing the estate, because we didn't even have a chance to get into this, but in America and in Europe, there are some professional rights clearing agencies that specifically work with artists to help maintain and steward and monetize their rights. And so if it is a European artist or American artist, you can go to these rights clearinghouse websites, type in the name of the artist to see if the agent represents that artist, and then you reach out to them. Now, in your hypothetical situation, if you have tried very, very hard to find that artist or artist estate or the agent, and you can't come up with anything, but you've made a very, very good effort, a good faith effort to try to find them, then I think the risk is lower.
But if I could interrupt, according to Saudi law, the rights, if the artist or whoever, the author, if they don't have relatives that inherit the rights, it goes to the government. Ranim, yes.
Oh.
And then it remains owned by the government, the rights, the intellectual property rights for, I think, 70 or 50 years. I'm not sure about the number of years. Yes, it is.
There's no one to inherit.
Yeah, because I have a hypothetical situation where I need to copy certain catalogs, exhibition catalogs. And so, yeah.
So then, Eiman, maybe I can ask you, because this is so fascinating. So in your hypothetical situation, and you're pretty sure that the government now owns the rights to the artist's work.
Yeah.
Then is the curator expected to go to the government, or is there some sort of rights permission process that's required?
I will tell you a hypothetical situation. No, but it's true. I really, we did that for the MoMA book, by the way. You go to a representative of some sort for the entity that owns the work. For example, for the catalogs, for Muhammad Salim, when we were reprinting part of it for MoMA's book, we went to الجمعية العربية للثقافة والفنون because we know that the artist did the exhibition, but they funded the exhibition. So no one of the people who actually worked on that catalog were in office at the time we were going there. So the ones who were feeling oh my, is it too political to say it? So anyways, so the person who was filling for them was happy to sign a paper for us, giving us the right to. Honestly, I find government officials are very cooperative in that aspect. The only thing that we have to provide is to say who's using it, and then also to confirm that this is for academic purposes or for scholarly purposes. Although it is sold, the book is sold, you know that, and this was cleared way before MISC was actually founded, let alone sponsor the book. Yeah.
But if it's Salim, then and the inheritance are still
no, they don't have the right over the catalog of the
okay, so
because we were using
that was already used. Okay.
we're using text of the catalog, and the catalog has the logo of the
it already has,
but the body that has the logo is no longer existing, by the way. So we went to the other, which is the الجمعية العربية للثقافة والفنون, because it was the representative, and this is also before وزارة الثقافة, so no one would say anything from وزارة الثقافة, Minister of Culture. It's honestly, this happened in 2016. We worked on that issue from 2015 to 2016, and it is a gray area, and I believe sometimes it's a good thing that it is a gray area, because it's always negotiable, especially for pioneer work or so. But the thing is, there's in law, in Saudi law, there's always someone representing the intellectual. If not the artist family, they don't have relatives, it is the government.
Well, and I think, sir, just to reflect on that, in some ways, the government will always have some sort of a benefit. They will find a benefit, I hope, to say, if Saudi artists
they consider it as a national treasure.
Yes,
yeah.
Right?
So this is why.
And so I imagine they're actually quite happy, for example, for a Saudi artist to be represented in a book, to be in a scholarly publication. That furthers the awareness of Saudi artists and the art history behind these artists.
Yeah. So any hypothetical situation, Ranim, just call me, and I will tell you. No, it was really great to have this conversation. I'm sure people. Oh, you have a question.
I have a quick question. There's a lot of fear on developing, especially for paid proposals, and a lot of, like you said, there's a lot of commissioned work, but even proposals for developing projects with artists, architects, and others. And then I know in Dubai this became a major issue when they did competitions for the first frame, where there was a big copyright and legal issue with the artists, who they then changed the original format of the frame and turned it gold, and it was a major dispute. But here I know there's a lot of hesitance with artists and others or creatives to share their proposals.
Yeah.
Because they're often the inspiration behind a lot of the projects, or they're altered. How do you protect against alterations? Because eventually the clients or the commissioners, you know, stand behind kind of alterations as not an original work. So it's maybe inspired by, but so because there's that hesitation, what do you think in this ecosystem has to happen to either help, train, create policy for, or some kind of practice that allows artists to feel a bit more confident, put their work out there, or to protect it, not put it out there enough?
So thank you so much for that question. It's not a simple question, right? I think it's sort of a developing sort of area in terms of best practices and standards. And the way that I see it sometimes happen is that in architecture competitions, or if, for example, an architect or designer has been specifically commissioned to create a proposal and submit a proposal, I've sometimes found that those proposals become the property of the commissioner, even if that designer is not selected, right? And then it turns out that that is the rule that they have to abide by in order for them to even participate in the competition. And I think it's not as strict, I think, in the art world. I think it is so important for artists to say from the top that even if they create a proposal, that proposal in a fixed tangible format has copyright protection, and it is theirs, and that they are sharing the proposal for consideration by the commissioning organizers. And I've also seen artists advocate for themselves to say, if I don't get selected for this commission, then I'm permitted to workshop or take this commission elsewhere. And then I find usually that the commissioning organizer says, that's okay if you do not get selected, but please, for example, add a historical credit line that says, I initially prepared this proposal for so-and-so commission, but I'm now using it for another project.
And can I just add something related to Saudi Arabia? In Saudi law, even if they add one line, you lose your copyright over your design, right? I personally, I was in a participant, and they took the logo, they changed it, and it's fine. But they make it clear right in the beginning when you are participating that they could potentially take some inspiration of your design. So you are entering the competition willingly, knowing that. The other thing that I would answer from a different perspective, not from a legal perspective. What I usually tell artists, especially younger ones, is that there's always a chance, a 50% chance of losing your creative design or whatever for that competition. But if you participate. But there's 100% chance that you will never win anything if you decide not to go through it. So it is always worth taking that risk, honestly, especially if you're early in your career.
And just the integrity of the actual product, the ability for commissioners to completely alter and change it while
unfortunately
still using your name or copyright. So that's one of the...
Actually, they do it to save money in many cases where they...
And I'm sorry to hear that that happens. And in certain parts of the US law, it's not fully the case, but in certain states, for example, US artists have the right called moral right. And that is also a set of rights that I know that Saudi Arabia does not have. The US generally doesn't have it. In Europe, it's much more fleshed out. But the moral right of an artist is to be able to say, if somebody takes my work and adapts it so much, I have the right to say this is no longer my work. So it's the right to disclaim the artwork if it's so adapted.
Yeah. So any questions? Yeah, it's such a tricky.
But I love the advice that you just gave, because if the artist doesn't participate, they will not get selected.
Ever. At all. Yeah. So thank you very much, everyone, for joining us tonight.
Thank you so much.
Thank you,
such an
Yayoi,
honor.
for
Thank you.
Very, very
Thank you, Eiman. It was wonderful. Thank you.